proceed to health and safety and security, let me tell you what this is all about. Every organization has health and safety and security in order to provide their employees as well as employers with a safe place to work. It secures risk assessments and encourages people to improve their health and safety, and it provides trainings and guidelines for reducing risk and adhering to safe working methods. Health and safety and security also has the function of securing the well-being of both the employee and the employer, which include the following: providing restrooms, changing rooms, and washing spaces, ensuring a healthy working environment, including a pleasant temperature, access to drinking water, adequate lighting, and adequate workspace. Next, determining the health risks and safeguarding employers' exposure to hazardous substances. Next, assures that technical equipment is properly installed and used. Next, provides safe access and departure routes. Health and safety and security are categorized into 4 benefits, which are general benefits, health benefits, safety benefits, and security benefits. These 4 benefits have both an impact on employees and on the organization. You will see on the screen the following general benefits of health and safety and security on the employees on the organization. The next one is health benefits. It includes health insurance, employee assistance program, and health screening on the part of the employee. The third one is safety benefits. It includes employee retention, identifying all workplace safety hazards, and helping managers and employees to always stay connected. The last one on the list is security benefits. Take a look on the following benefits on the employee and the organization under the category. Safety health standard. We need to understand that the company should have a unified framework for their efforts to reduce accidents and risks in all work situations. Also, employees should feel that they are in safe and comfortable work environment, and OSHS Act is suitable for that. But first, what is OSHS Act about? According to Assay and Mercer, the new OSHS Act, also known as RA 11058, which states that employers are now required to comply with occupational safety and health standards, including updated training requirements, on-site mandatory clinic establishments, compliance audits and tracks, inform workers about any hazard and the right to refuse unsafe work, as well as the provision of safe facilities and personal protective gear. So basically, OSHS Act is an act wherein the company should comply with the occupational safety and health standards. In order for employees to have an enhanced working environment, the old OHSS in 1989 became the new OSHS law. This new RA 11058 legislation changes the Philippines 41-year labor code and includes all facilities, projects, sites, and other places of employment other than the state sectors, including the Philippines economic zones. It was signed by President Rodrigo Duterte in August 2018 to become a law. This law provides that every Filipino employee is protected against injury, illness, and death through secure and helpful working stipulations, and that employers must promote strict but dynamic, inclusive, and gender-sensitive measures in development and the implementations of policies and programs that are related to occupational security and health. Who exactly are benefited and protected by this law? This act covers all establishments, project sites, including PESA establishments, all other places where work is being undertaken in all branches of economic activities, and the exception for this is the public sectors. These covered offices should have an occupational safety health or OSH program that is accredited by DOLE. Occupational Safety Health Program are in the Section 12, Chapter 4 of the Republic Act No. 11058. The OSH program must have the following. Covered workplaces shall have a safety and health program including these policies, guidelines, and information. Safety and health program must be approved and communicated to all the persons in workplace. Based on the Republic Act No. 11058, Chapter 3, there are duties and rights of employers, workers, and other persons that they must know. First, let us discuss the duties, which is in the Section 4, Chapter 3 of the Republic Act No. 11058. Duties of employers, workers, and other persons. First, must provide safe working environment for workers and free from hazard that are causing or are likely to cause death, disease, or physically harmful. Next, provide comprehensive job safety instructions or orientations to all employees, particularly those who are new to the job. Must inform the workers properly about the dangers or hazards associated with their work, including the health risks they may face, preventive strategies to reduce or eliminate the risks, and know what to do in an emergency. Next, must only use approved devices and equipment. Next, must comply with OSH standards, which including training, medical exams, and the provision of protection and safety measures such as personal protective equipment or PPE and machines guards if needed. Next, must allow workers and their safety and health representative to actively engage in planning, implementations, and evaluation of safety and health program in order to promote workplace safety and health. And lastly, must provide necessary plan for emergencies and accident preparedness, including first aid arrangements. And for workers, every worker shall participate in ensuring compliance with OSH standards in the workplace. Here, workers must make proper use of all safeguards and safety devices provided for their own and other protection, as well as to follow all instructions to avoid accidents or dangerous situations in the workplace. For any other persons, anyone's required to follow the terms of this. Anyone is pertained as those people who visits, builds, renovates, or install devices or do some business in any establishments or workplace. Are the rights of the employers, workers, and any other persons according to Section 5 of the Chapter 3 of Republic Act No. 11058. The workers have the right to know. Section 5, workers must have enough knowledge or information about all forms of hazard they may face in the workplace. Next is the Section 6, which is the right of the workers to refuse the unsafe work. Section 6, the workers has the right to refuse to work without fear or retributions for the employer. On the other hand, the worker's right to report accident is written in Section 7. Section 7, workers and representatives have the right to report workplace accidents, harmful events, and hazards to their employers. Section 8 talks about the right of the workers to personal protective equipment, or PPE. Section 8, the employers must provide the free PPE to the employees, such as protective equipment for eyes, face, hand, feet, and any other protective gear that is necessary for work to avoid injury or any accidents provided in Section 9 are the safety signage and devices. Section 9, workplace must have safety signage and devices to warn workers and the public about the workplace hazards. It should be placed in prominent and strategic locations and in a language that is easily to understood by all and of course in accordance with DOLE standards. Next is the safety in the use of equipment, which is found on the 10th section of this Act. Section 10, in terms of equipment use, the employer must follow the DOLE regulations at all times during the firm's operation, including the transportation from the establishment's project, site, or place where work is being done. And lastly, Section 11, which talks about the occupational safety and health information, which is also under the duties and rights of the Chapter 3. Section 11, workplace shall provide adequate and appropriate information about safety and health hazards, as well as the required steps for preventing, controlling, and protecting against those hazards, including the likely locations of the workers. Have you ever wondered Who's the person responsible for observing and enforcing this Occupational Safety and Health or OSH program? According to the Republic Act number 11058, Chapter 4, Section 13, there should be a Safety and Health Committee to ensure that safety and health programs will be observed and enforced. A Safety and Health Committee is comprised of the following. We already learned that there is a person responsible for observing and enforcing OSH program. Now, we will get to know who's responsible for ensuring that OSH program is duly followed and enforced. And yes, it is different from the OSH committee. They are the safety officers, which could be found on the next section. Next is Section 15, Occupational Health Personnel and Facilities. Qualified occupational health personnel such as physicians, nurses, licensed first aiders, and dentists are required to be present on covered workplace together with the necessary medical supplies, equipments, and facilities. 16th section is about the safety and health training. Section 16, this section states that all safety and health workers must complete the DOLE mandated basic occupational safety and health training for safety officers. Next, all workers must don a mandatory 8-hour seminar as required by the DOLE. All personnel engaged in the operation, erection, and dismantling of equipment and scaffolds, structural erections, excavations, blasting operation, demolition, confined spaces, hazardous chemicals, welding, and flame cutting shall undergo specialized instruction and training on the said activities. Next in line is Section 17, Occupational Safety and Health Reports, stating that the employers shall submit all safety health reports and notification that are prescribed by DOLE. According to Chapter 4, Section 18 is the Workers' Competency Certification. An occupation shall be considered critical when the performance of a job affects the people's lives and safety. Next, the job involves the handling of tools, equipment, and supplies. Next, the job requires a relatively long period of education and training. Next, the performance of the job may compromise the safety, health, and environmental concerns within the immediate vicinity of the establishments. Also from Chapter 4 of the Republic Act number 11058 is the Section 19, Workers' Welfare Facilities, which consists of the following: that welfare facilities must have to ensure humane working conditions, adequate supply of safe drinking water, adequate sanitary and washing facilities, suitable living accommodation for workers as may be applicable, and separate sanitary and washing and sleeping facilities for men and women workers as may applicable. And for the 20th section is the Section 20, Cost of Safety and Health Program. According to this provision, the total cost of implementing a duly approved safety and health program shall be an integral part of the operating cost. Do you know that there will be a corresponding consequence if the employer failed to comply with the OSH standards? Section 18 Prohibited Acts discuss that a failure or refusal of an employer to comply with the required OSH standard shall make them liable for an administrative fine not exceeding 100,000 pesos per day until the violation is corrected or counted. But the amount of fine imposed depends on the frequency or gravity of the violations. A failure or refusal to comply with the required OSH standard shall be liable for a maximum 100 pesos if repeated obstruction, delay or refusal, misinterpretation in relation to adherence to OSH standards, reporting, recording, or submitting false information in any material aspect to DOLE, knowing such as a statement, making retaliatory measures such as termination of employment, refusal to pay, reducing wages and benefits, or in any manner discriminates against any workers who has given information relative to the inspection being conducted, To close this topic and to add further information, the fine collected shall be used for the operations, occupational safety, and health initiatives, including the training, educations, and other occupational safety and health programs.
Employer duty of care confidential record keeping. According to Panda's team, confidentiality refers to personal information shared with attorneys, doctors, therapists, or other professionals that would not normally be disclosed to third parties without the client's express consent. Confidential information is regularly handled by financial institutions, hospitals, doctors, therapists, law firms, businesses, religious authorities, and others. These professionals often have specific rules and regulations for handling confidential information, but others protect confidential information by contract. Record keeping is the activity of organizing and storing all the documents, files, invoices, etc. relating to a company's or organization's activities. Now let's talk about why is confidentiality critical to human resources. According to SHRM.org, human resource professionals must understand the importance of maintaining the confidentiality of sensitive employee information, including social security numbers, performance reviews, workplace injury reports, background checks, health-related information, pay levels, etc. Legal obligations such as data breach notification requirements and privacy laws. For example, the Health Insurance Portability and Accountability Act, or HIPAA, require employers to establish processes and procedures to secure and safeguard sensitive employee data and notify employees of any breach of this confidential information. In addition to protecting sensitive employee information, HR must maintain confidentiality about management or business information that is not available to non-management employees or outsiders. Such information could include changing business strategies and processes, layoffs or plant closings, or proprietary data. According to Federal Records Management and Shredding, there are 3 types of confidential documents you should keep an eye on at your workplace. Number 1, contracts and commercial documents. Contracts and other business documents are among the most significant secret documents. To protect both your company and the third party, confidential documents must be handled and kept securely. A confidentiality clause is included in almost all contracts. Your contract with your important clients could become void if it fell into the wrong hands. Contracts also contain a lot of sensitive information, the cost of the services as well as the names of the parties engaged. If a competitor obtains this material, they may use it to harm your company or steal your customers. Number 2, confidential employee information. Another important aspect of confidential documentation is employee information. This includes personal data such as social security numbers, date of birth, marital status, emailing address. Identity theft and fraud are avoided when employee information is kept secure. However, there is a lot more information on employees that should be kept in secure files. Employer resumes, background checks, interview notes and tests, performance reviews, and disciplinary paperwork are all part of this process. Pay rate, employment contract, number of benefits, vacation, and bonuses are all examples of secret documentation. And last, office plans and internal documentation. Many people don't realize that their office floor plans, seating arrangement, internal processes, and procedure manuals are confidential documents. Most businesses have detailed office layouts that incorporate things like exits and seating plans. You almost certainly have some procedures that employees must follow in order to do their jobs. Yes, they are all accessible to all your employees. However, you do not want it to get into the hands of people who will misuse them. If at all possible, save these materials electronically. Employees should be asked to keep printouts to a minimum. When a version is no longer needed, be sure it's securely shredded. According to Blueprint, there are 8 ways to keep confidential documents secure. Number 1, implement a workplace information destruction policy. Having a predetermined policy for information destruction will help to eliminate any confusion about what to destroy and when. When putting in place a workplace information destruction policy, make sure to include procedures for both daily records and those with a longer life cycle. Number 2, Implement a clean desk policy. When you leave important documents on your desk, they become more vulnerable to a data breach. Visitors, cleaning workers, and other employees can easily access confidential information if they are kept in plain sight or in a file folder. At the end of the day, all documents should be sealed up. On desktops, no paper or confidential information should be left. While the documents are still in use, locking up this information guarantees that it remains secure. Number 3, train employees on the importance of document security. Employees should be trained to handle confidential and proprietary information with care and to respect the sensitivity of the information. Specifically, you should train your employees to protect confidential information regardless of the media type for the entire life cycle of the information. Shred all paper documents regardless of their sensitivity and lock up all sensitive documents that cannot be used. Share confidential information only with those who need to know. Have a written, signed confidential non-disclosure agreement before disclosing confidential information to third parties. Promptly report any actual or suspected unauthorized access to management. Number 4, include a non-disclosure clause in employment agreements. To secure your sensitive business information, it's best to have your employees sign confidentiality and a disclosure agreement. This will protect your firm and inform your staff that proprietary information should not be distributed or shared. Secrecy clauses in employment contracts show that your company values confidentiality and might assist you avoid legal and practical issues. Number 5, limit access to sensitive information. Only those personnel who have a need to know should have access to confidential information in a company containing confidential information. Electronic copies of paper should be password protected and hard copies should be kept locked. Number 6, have a strict visitor policy. Visitors to a workplace should sign a confidential agreement when they arrive if it is suitable. They should also be escorted at all times and kept away from areas where personal information may be exposed unless they have need to know. 7, secure paper document storage. Steps must be taken to guarantee that any physical papers are as safe as possible from theft. Begin by ensuring that the location where they are all kept are secure at night. Employees should be taught how to secure critical papers and double-check that they are secure. Investing in safe off-site storage for records that require a longer retention time might also be beneficial. After that, the information is carefully managed and protected. When necessary, you will still have access to all printed documentation. And last, number 8, always back up. Always back up your information if at all possible. Scanned physical documents should be saved on secure servers. If the worst happens and you lose, steal, or damage any of your secure documents, you will still be able to access them when you need them. Under Republic Act 10173, Data Privacy Act of 2012, Chapter E, there is a list of penalties that the organization may face if they fail to do so. Disciplinary and grievance. This will be the last topic in employee duty of care. First things first, let us define what discipline and grievance are in the corporate world. Discipline is the management complaints against an employee, while grievance is an employee's complaint against the management. Discipline and grievance, when combined, are each one side of the same complaints coins. The arrangement for handling issues vary considerably from employment to employment, depending on a wide variety of factors including the terms of contracts of employment, locally agreed procedures, industry agreements, and whether trade unions are recognized for bargaining purposes. There are procedures for dealing with such issues reflecting the varying circumstances of enterprises or organizations. Must comply with the general principles of natural justice and fair procedures, which include. So now let's proceed to types of disciplinary actions. There are 6 types of disciplinary actions, and they are listed as follows. 1. An oral warning or verbal counseling. 2. A written warning. 3. A final written warning. 4. Suspension without pay. 5. Demotion, transfer, and reduces, raises, or bonuses. And 6. Dismissal or termination. According to research conducted by several companies, there are benefits of having an employee grievance procedure. What are they? Let me discuss it further. Benefits of having an employee grievance procedure. Number 1, a formal grievance procedure gives employees a chance to challenge management's decisions, voice their opinions and concerns, and provides an opportunity to resolve conflict quickly, fairly, and effectively through conflict management. It can help also foster trust, since having a written grievance procedure encourages employees to raise concerns without fear of retaliation. Number 2, prevents minor complaints or disagreements from spiraling into something more serious. Number 3, encourages you to develop company policies and employment contracts that are highly specific and have clear expectations. 4, helps foster a company culture of transparency, openness, and trust. 5, makes employees feel heard and valued. 6, helps prevent and address bias, discrimination, and harassment in the workplace. 7, gives employees a tool to resolve their problems instead of quitting or being less productive. And last, serve as a cost-effective way to resolve problems and disputes before they result in litigation. Here are the 5 employee grievance process that can be used. Number 1, informal meeting with supervisor. Before filing a grievance, encourage employees to talk with their manager first. Often having an informal chat with a supervisor is all that's needed to resolve a complaint or workplace issue. Number 2, formal grievance in writing. Consider creating a grievance form for employees to fill out. You can also have employees send an email with details about the grievance. Encourage employees to include as many details as possible, including names and dates, depending on what your grievance procedure policy stipulates. You can also have employees verbally make a complaint and have the supervisor write down the employee's statement. Number 3, evaluate the grievance. At this stage, you may choose to look in your human resources department. For unionized workplaces, this is typically where union representatives get involved on behalf of the employee. Number 4, conduct a formal investigation. To conduct a formal investigation, you may need to interview the employee who filed the grievance as well as anyone else who was involved. Collect any evidence you can to help you come up with the resolution. For example, email chains, witness testimony, receipts. You may also choose to appoint an independent investigator to conduct the investigation to keep the process fair and unbiased. And last, resolution. Finally, the investigator, HR, supervisor, and anyone else who was involved in the investigation writes a formal conclusion based on their findings. Let the employee know what your decision is and what action you'll take. If the resolution isn't satisfactory to the employee, mediator may be called in to help resolve the situation. If you offer employees the right to appeal the final decision, make sure to include this in your grievance process policy.